Welcome to Kanooni Charcha. Today I will discuss the relevant provisions of Section 319 of Code of Criminal Procedure, the cost pending provisions of BNSS, Bharatiya Nagrik Suraksha Sanhita 2023 is 358, I think. Now, what is this section? What are its ingredients? What relating which this operate? What is its mandate? I will discuss all things and simultaneously. And in this episode, I will also discuss the relevant recent judgment of Honorable Supreme Court of India with regard to Section 319 of Code of Criminal Procedure. When it is applicable, at what stage of the proceedings in a criminal trial it is applicable. It can be made operative. Now I will read out firstly the section 319 of Code of Criminal Procedure. Section 319. Power to proceed against other persons appearing to be guilty of offence. Now I will read and then I will discuss this. Interpret. Where in the course of any inquiry into or trial of an offence, it appears from the evidence that any person not being the accused has committed any offence for which such person could be tried together with which he appears to have committed the offence. Now I will repeat here. I think one, with the accused, the court may proceed against such person for the offence which he appears to have committed. In short, this what I have gathered from this section, when a trial is going on with regard to any trial, with regard to any offence or offences committed under Indian Penal Code or any special act, you may say, to which the Code of Criminal Procedure is applicable. If trial is in operation, in currency, and during the trial, if some evidence comes, obviously when prosecution is leading evidence or complainant in a complaint case is leading evidence, some evidence is found or otherwise it comes against a person who is not accused facing the trial. A person who is not facing the trial, but some evidence is available against him, which requires his pleading as a accused in a particular case. This is, I think, crux of this section. Now the question rises, now it is when trial is continuing, this is also you will find in this section. Any person not being accused has committed any offence, if the court finds and when court has an evidence led by the prosecution or by complainant whatsoever, that evidence is there against a person who is not an accused facing trial, then court can intervene and take the necessary actions, necessary proceedings by issuing someone runs whatsoever is, but in the currency of trial, and there must be an evidence available from which it can prima facie be drawn, inference can be drawn that he has committed the offence, and he is required to be tried together with the person accused who are already in trial before. Now I will read. I will now refer the relevant judgment, recent judgment of Supreme Court of India. This judgment is titled Devinder Kumar Pal versus State of Uttar Pradesh and another. This judgment is authored by Justice B.R. Gowai J. What happened in this judgment? This is a appeal earlier was filed against this judgment and order dated 25th of August 2021, passed by the learned single judge of the High Court of Judicature at Allahabad. This judgment of a single judge has been assailed in this petition before the Supreme Court of India. Earlier how the matter came before the Honorable High Court. The order was passed by the learned additional session judge, hereinafter to be referred. This is in para 2 you will find, dated 21st of March 2022, was an application filed by the appellant challenging the order passed by the learned. The order of additional session judge was dismissed by the High Court. Now I will come to there was a trial pending going on in this in terms of section 302 of Indian Penal Code. Offence was a trial was going on before the trial court. It is an additional session judge court. After conclusion of the trial, when trial was about to end, there was a conviction order announced, and simultaneously some accused were acquitted and some were sentenced. What happened? I will read out afterwards, but I will narrate you what is in the order of the session judge. Earlier in the pre-lunch period, this court asked, he convicted and postponed the matter for sentencing after this lunch hours. What happened after which he sentenced the accused and other accused who were not convicted earlier were acquitted. This is the mean when some were convicted and some were acquitted. The accused who were convicted pre-lunch hour of the court was sentenced post. After sentencing, after completing this, you may say, trial and pronouncement of judgment of the conviction and sentence, a order was passed by the trial judge that by which he summoned an additional accused. Against this order, the approach was made before the Honorable High Court. Now I will read para 7 seems to be relevant. But I have spoken verbally. You will gather it. By an order dated 21st of March 2012, the learned trial judge in the first half recorded the order of the conviction in respect of accused whom it had found to be guilty, and also recorded the order of acquittal. This is pre-lunch proceeding. For remaining accused, it found to be not guilty. Post-lunch, after lunch hour of the court, the learned trial judge first recorded the order of sentence in so far as accused who were convicted earlier, and thereafter the learned trial court judge has passed an order summoning the present appellant Devinder Kumar for trial by invoking powers under the section 319, which I have already read in the spot of the Code of Criminal Procedure. Now, this is what happened, that after conclusion of the trial, conviction, sentence, a order was passed for summoning the appellant by the trial court. This order was assailed before the Honorable High Court of Allahabad. The application, the whatsoever that was dismissed by the High Court. The prayer of the appellant Devinder Kumar Pal was refused by the High Court. against which earlier he has a prayer was against the order of summoning him as an accused by the trial court, by the judicial session. I have read. Now relevant para in this is para 12 of the judgment. It relates to the there was arguments on behalf of the appellant, this Devinder Kumar Pal, and in reverse there was a judgment of there was argument of this state side. Now the assistance of Honorable High Supreme Court of India has observed as in para 12 has drawn a finding that this matter has already been cleansed. How Honorable High Court has dismissed the prayer of the accused, and there was no occasion with the trial court to summon the accused when he has already concluded his proceedings of trial whichever he was holding about the murder trial. Now I will read out the para 12 which is relevant. It will be relevant to refer here. Para 33 of the judgment passed by the Constitutional Bench. This was a Constitutional Bench of this court in case Sukhpal Singh versus Sukhpal Singh Khaira, which reads as para 30 is being reproduced here of earlier judgment of Sukhpal Singh Khaira. This is Sukhpal Singh Khaira versus State of Punjab, I think. Now para 13 provides there is a question answered by the by the Honorable Supreme Court of India earlier in Sukhpal Singh Khaira's case that has followed in this judgment by the Honorable Supreme Court. Now I will read out the point answered. For all reasons stated above, we answer the questions referred as under. It's a first question. Whether the trial court has power under section 319 of Code of Criminal Procedure for summoning additional accused when the trial with respect to the other accused has ended and judgment of conviction rendered on the same date before pronouncing the summoning order. Similar are the facts here. In this case, some of the accused were acquitted, some were convicted in the pre-lunch hour of the court, and the matter was postponed for conviction. This after the accused who were convicted for sentencing them on quantum of sentence after this post-lunch hour, they were sentenced accordingly. After doing all this, the court made an order of summoning of the accused Devinder Pal on the by referring that there is evidence against him, he is required to be tried. Now the answer in this whether the trial court has power under section 319 of Code of Criminal for summoning additional accused when the trial with respect to other co-accused has ended and judgment of conviction ended on the same date before pronouncement. This was the question. This is required to be answered. The power under section 319 of Code of Criminal Procedure is to be invoked and exercised before the pronouncement of the order of sentence where there is a judgment of conviction of accused. In case of acquittal, the power should be exercised before the order of the acquittal is pronounced. If the case has to result into acquittal of the accused, after acquittal, no order can be passed because obviously court is functus offshore. There was no proceeding by this section provides when the trial is in operation, in currency and evidence is against the accused. Somebody who is not accused before the court, he can be summoned. But during the trial, this is answered. If hence the summoning order has to be precede the conclusion of trial. But in text, it should proceed. It should be at this antenatal time. This is prior in time to the order of conclusion of the trial. Hence, the summoning order has to be precede the conclusion of the trial by imposition of sentence in the case of conviction. If the order is passed on the same day, it will have to be examined on the facts and circumstances of each case. And if such summoning order is passed either after the acquittal or imposing the sentence in the case of conviction, the same will not be sustainable. This is in crux, in short, question answered in this case of Punjab, this Supreme Court of India, again this case of Sukhpal Singh Khaira. In this case, it was question was framed and it was answered when the trial is concluded, means this conviction is there or acquittal is there. If conviction is there and afterwards sentence is part is or component or part is over, obviously there is no case. The total trial has already been concluded. The summoning order of an additional accused cannot be passed. This is a question answered in this judgment, which has assistance of which has been taken by the lordship in this judgment. Now, para 13. Now I will indisputably in the present case on 21st of March 2012, the order of conviction in case of some other accused and order of acquittal in case of other accused was passed in first half. This is a repetition of the earlier. In second half, the court first passed an order for sentencing of the persons who were convicted and only thereafter passed an order under section 319 of Code of Criminal Procedure for summoning the present appellant. Now, this is the earlier reference made. This is observation when the trial court has, whether the trial court has occasion to pass such an order. The Constitutional Bench, which is in this judgment I have referred here now, the Constitutional Bench has clearly held that if such a summoning order is passed either after the acquittal or imposing of sentence in conviction, same may not be sustainable. Now, sitting in two judge combination, we are bound by the law laid down by the Constitution Bench. The bench in this judgment of consisting of two judge combination, two judges bench. And earlier the point decided was by a constitutional bench. The framed and answered. As a result, the appeal is allowed. Earlier dismissed by the High Court. As a result, appeal is allowed. The impugned judgment and order dated 25th of August 2021 passed by the learned single judge of the High Court. So also the order of summoning order by the learned trial judge dated 21st of March this 2012 in respect of present appellant under this section 319 of Code of Criminal Procedure quashed and set aside. Both orders of trial judge summoning of the accused Devinder Kumar Pal and the order remained upheld by the High Court of Allahabad. Both the order were satisfied, quashed, and this is the judgment appears to be judgment authored by B.R. Gavai and with other judge Justice was this with who have also in the bench K.V. Vishwanathan. K.V. Vishwanathan was also with Justice K.V. Vishwanathan was also in the bench, and this judgment seems to have authored by Justice B.R. Gavai. Now, this is judgment dated 6th of September 2020, very recent in time. Now, I think the viewers, this is very important judgment. Generally, a mistake, error, illegality is committed by the judges. In application of section 319 of Code of Criminal Procedure, corresponding is this 358 of this BNSS. Sometimes what happens when accused are this what happened in this case, I will repeat, after acquittal the prosecution must have laid a prayer, or otherwise the court at its own trial court has found that evidence is there, and evidence is there for an person. He is required to be arraigned as accused, but the section the 319 of Code of Criminal Procedure speaks that I will repeat here, where in the course of inquiry or into or trial of mean an offence it appears from the evidence that any person not being the accused has committed. I will give a pause here. So this section is when trial of a case is in currency, is in operation, then the this section can be invoked by the trial court, and when it is completed by making an acquittal order, conviction and sentence is there, then after that no order can be passed. But here in this case, trial court has passed order after making acquittal and conviction of some accused and some of conviction and convicted and sentenced. After that, this order was passed in post lunch hour of the court. This order of the trial court was upheld by the High Court. This prayer made by before the Honorable Court was refused. After that, a matter came to the Honorable Supreme Court of India. Supreme Court of India quashed both the orders. This is the crux of this judgment. I think this is sufficient for today. If I will again come to you. Thank you very much.